Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at NPZ Law Group, Nachman, Pawani, Zimochek, and I have with me today my colleague Felicia Zeidman. Felicia is an attorney in the United States and also in Canada. Felicia and I work in the area of business immigration. These are individuals who are immigrating into the United States for business reasons. They're intra-company transfers. These are individuals who are highly skilled workers coming to the United States who are generating jobs for U.S. workers and increasing our economic infrastructure here in the United States. We have offices in New Jersey, New York. We also have an affiliated office in Mumbai, India, where I will be next week. And we also have an affiliated office in Canada where Felicia spends some of her time. Today, we want to spend a little time talking to you about something that we've gotten a lot of questions about because unfortunately, we're in an environment for some reason, and it's never easy to predict, that there have been a tremendous number of layoffs. And the layoffs are incredibly important to us as immigration lawyers in the business realm because what ends up happening is that a lot of beneficiaries, individuals who are intending to immigrate to the United States, have petitions in play for their corporate employers where what happens is, for example, a corporate employer will initiate a labor certification process, will initiate some kind of a pre-certified classification for the green card. For example, in the EB-1 classification, you have, as many of you know, you've seen our videos before, extraordinary ability, outstanding researchers. EB-1-2, EB-1-3, or EB-1C is multinational executives, transferees like the L1s. So a lot of people know that if you have an L1A, you can go to an E1-3 multinational executive. It's a nice, smooth ride over that way. Also, if you have H-1Bs, to go to labor certification. So what happens in the context of a termination? And this is a big question that we've been getting is, let's say you have a green card in play. How does a termination affect you? Now, I guess number one, the first part of the analysis is, how does the termination affect you for non-immigrant purposes? So that's not really what we want to talk about today because we can do that in a separate video. We're going to talk about non-immigrant termination because that depends upon what type of visa you're on. Because if you're on an H, then you're going to have a possible, you're going to have something to do with the Department of Labor, you're going to have something to do with the CIS. If you're on an O, maybe you just have to withdraw. But what we're talking about today is we're talking about people who have initiated green cards, which are employer-sponsored green cards. And then there's a termination or a layoff. So what do these individuals do? Well, the thing is that what we want to do is drive home that you shouldn't give up hope. There may be options for you. And so, for example, if you're in the E11 category, or you're an outstanding researcher, or let's say a national interest waiver has been initiated for you from the employer standpoint, are there still options for you?
David, it's a good question because people have put a lot of stock into coming to the United States. They've given up everything at home sometimes to get here and pushed very hard to get here. You know, all of our viewers will probably be able to relate to that or know somebody who's put in a lot of effort to get here to the United States. And the interesting thing is that there are some visas that exist that are self-petitioning.
That's right. That's exactly right.
Right.
And so one of the self-petitioning visas is the extraordinary ability, E11. But what with the E11, what is it that we know about the E11? It's a very high legal standard, right?
It is. And you have to risen to the top of your field of endeavor.
That's exactly right.
And often, one of the criteria, for example, is to have won a major award. Okay?
That's exactly right.
It doesn't have to be.
If it's a Nobel Prize, that's great, but not many Nobel Prize winners walk into our office off the street.
Right. That's kind of challenging to come up with. So otherwise, there are a series of criteria that can be used to show that you do have extraordinary ability, and those criteria can be handled in a way. There's a number of them, about 8, and out of the 8. Often people will have accomplishments that will fit under 2 or 3, and all you need is 3.
That's right.
And there's even one criteria which is comparable evidence. In other words, if you have extraordinary ability in something that is not off the shelf, okay? So let's say you are a carpenter, okay? They don't really envision carpenter with these types of things. However, your carpentry has become very high-end, or your carpentry has won major awards, or your carpentry is exceptional in some way. There is a way to present that for real consideration by the USCIS.
Exactly. So E11 is in fact one potential option to look at for self-petitioning. The other thing that you should do is if you've initiated a petition through an employer, and let's say it's any one of those classifications that we've discussed, then of course you can also possibly think about going to the self-petitioning national interest waiver. Now we've done some other videos on the use of the national interest waiver, and what you do is you have to demonstrate that the individual is exceptional in their field, and that the work that they're doing is in the nation's interest, and it has to be intrinsic to the nation as a whole. So these are the types of things that you would prove in order to have a national interest waiver. So in fact, a lot of the questions that we got this morning had to do with a major Fortune 100 company that had a very, very large layoff. They laid off hundreds of people, and those individuals had green card applications that were pending through employer-sponsored categories. They came and asked us, what are our options? And so what we did is, as Felicia properly pointed out, we said there are two classifications where you have self-sponsoring that goes on. Consider the possibility of the E11 and consider the possibility of the national interest waiver. Those might be two nice options for you.
And David, what kind of response did you get? Were people interested? Did they feel like they could actually contemplate that?
Absolutely. In fact, they were thrilled to hear that these were options that were available to them, because they thought that they had gone through so much time, so much effort, and to try to do the green card through the employer. They thought that since they were losing their jobs with the employer, that everything was lost altogether. But in fact, it's not necessarily lost. The best thing to do, talk to a qualified immigration professional, someone who you know knows what they are doing, and they will be able to provide you with your options. Now these options deal with timing, of course they deal with expense, but at the end of the day, the most important thing is that you might have a safety net and that you're not going to lose everything altogether.
Great, so don't just give up, basically.
Exactly.
Nowhere near it.
We don't give up on you, so don't give up on yourselves. Thanks so much for being with us today. We look forward to being able to bring you more cutting-edge information in the immigration arena. Thanks, and bye for now.
Bye-bye.